Last time we discussed about the three inherent powers of the state. These inherent powers are the police power, power of eminent domain, and power of taxation. As I was telling you last time, these are inherent because they are there as the moment the state is born, and that these inherent powers cannot be removed from the state even with the operating constitution. The constitution merely limits the inherent powers but never abolish it. So this time we are going to study about the concept of constitution. What is the meaning of constitution? According to Judge Cooley, a constitution is a body of rules and maxims in accordance with which the power of sovereignty are habitually exercised. And in sum, it is defined as the fundamental law of the land to which all other laws must follow. Whether it is the long definition or the simple definition, we always see to it that first adhere to the Constitution, that whatever law be passed will always be in conformity with the existing constitution of the land. Because at the end of the day, any law passed by a member of Congress which is against the provisions of the Constitution will be struck down for being constitutionally infirm, and that declared unconstitutional by the highest law interpreter of the land, the Supreme Court. So always bear in mind that laws passed by Congress must always follow the contents and provisions of the Constitution. What are the purposes or functions of the Constitution? So one, it prescribes the permanent government. Like for example, in the Republic of the Philippines, the government in this republic is defined by the 1987 Philippine Constitution. How well each part of the bureaucracy will run is already embodied in the 1987 Constitution. And for example, Article 6 is all about the legislative department, and therefore the legislative department has this function to do defined under that particular provisions of the Constitution. Article 7, which is all about the executive department, and the Article 8, the judiciary. So there is already that prescribed framework. There is already that prescribed things to do inside the Constitution. Another, it assigned to the different departments their respective powers and duties. So as I was telling you, legislative department, executive department, the judicial department, or otherwise known as the three branches of government. These three branches of government has its own powers and duties well defined inside the Constitution, and that is why we respect that so-called equality among them, that the three, although separate, they are equals, and that they have to observe hands between and among these separate but co-equal entities, because that is defined in the Constitution. So among the three branches, they are not hurt when the other branch act or function with this, because that is their definition of their function. So they have to respect each other because that is what is written in the Constitution. Another, established certain fixed first principles, and so there are principles like defined in the Constitution, to which the government is founded, to which the government will function, and that is why you cannot just simply set aside the operation of the Constitution, because that will affect of our services to the people, the delivery of our basic social services which are needed by the people, especially in times of difficulties like having typhoon, having pandemic. These things have to be founded in the Constitution. And even the government cannot run without this. And last, to promote public welfare, which involves the safety, prosperity, health, and happiness of the people. So it is also embodied in the Constitution that these branches of government operating the government have to consider always the general welfare of the people, and that it has always promote safety among its people, and that it has always to promote the welfare of the people. What are the things that the people needed? What are the things that the people government should be given by the government, because that is embodied in the Constitution. So what are the kinds of constitution? One, it is written, in the sense that the constitutions or the constitutions of the Republic of the Philippines. We have uh, a lot of constitutions already. At present, we have the 1987 Philippine Constitution. During the time of uh, President Aquino, after her installment as president after the EDSA revolution, there was the so-called Freedom Constitution. At the time of Marcos, we have the 1973 Constitution, and then we have the 1935 Philippine Constitution. So these constitutions are written in a document, in an instrument, which we can always go back, which we can always read, because they are always there, intact, embodied in one particular instrument, and can be always reviewed. So our constitution is written, conventional, and rigid, versus this unwritten, cumulative, and of course flexible. When we say unwritten, it is because it is not committed to writing at any specific time, but it is a collective product and accumulation of customary rules, judicial decisions, dicta of statement and legislative enactments of fundamental character, written but scattered in various records without having any compact form in writing. So it is unwritten because it is not embodied in one particular instrument, where people have sit down, talk about it, then that the result of the meeting have resulted into a particular instrument. So that is why it is called unwritten. And it is also cumulative because it is a product um, of the things which the people have followed, but it is not a product of any convention which a representative or the people themselves sit down, talk about it, and then um, submitted it for plebiscite to the people. So since it is unwritten and it is not embodied in one particular instrument, it can be easily changed by time. As time goes by, as time passes by, people with different interests, with different governmental interests may change it from time to time, since it is not written, and therefore it can be easily changed based on the perception of the people at the present time, or based upon the leadership of the person sitting in the government. So it is very flexible because it can be changed anytime at the whims and caprices of the people leading the government. So most of the time, it is said that the Constitution of the United Kingdom not embodied in any particular instrument, and it's said to be unwritten. But I heard that they are already defining their constitution in one particular instrument, and that it is no longer unwritten but a written one. What are the requisites of a good written constitution? So one, it should be broad. for it outlined the organization of the government for the whole state. It should not be for the present time only, but it must also look into up to the time that it will operate, up to the time that it is not changed, not altered. So that's why it is broad, that it has to be include things which are not available at the present time. However, it should also be brief, for its nature requires that only its great outlines should be marked, its important objects designated, and the ingredients which compose those objects be reduced from the nature of the objects themselves. So it means to say that it has no details to what to do or what are the um, ingredients, what are the very basic things to do. It will not be like that, because the Constitution is only a framework, and that it must not laws passed by Congress, for example, are the one uh, putting the muscle, putting the covering the framework with muscle. So that's why the Constitution should be brief only, because our lawmakers, our legislatures who have that great mind will pass a law, and then it will be embodied in one particular instrument, where that will now be the muscle that will cover the brief description founded in the Constitution. The last but not the least, it must be definite, for any vagueness which may result in the opposing interpretations of its provisions may cause incalculable harm and chaos. Because it should be free from double edge, it should be free from ambiguity, vagueness. Otherwise, if it will be open for so many interpretations, it will be hard for us to define what particular action or things to do for that, because that is vague. Anything that is vague is hard to get, so it has to be cleared enough when writing a constitution. So what are the parts of a constitution? One, we have the Constitution of Government. The Constitution of Government outlines the framework of government and its powers and defining the electorate. So, if you look at the 1987 Philippine Constitution, example of this Constitution of Government are Article 6, or the Legislative Department, Article 7, the Executive Department, and Article 8, the Judiciary. Also, Article 5 on suffrage, Article 4 on citizenship. These are example of constitution of government embodied in the 1987 Philippine Constitution. Well, it defined the framework of government, including what the powers to be exercised, and of course, who are those that can be considered part of the electorate. We also have the Constitution of Liberty. The Constitution of Liberty are provisions which set forth the fundamental rights of the people and imposing certain limitations on the powers of the government, and as a means of securing the enjoyment of these rights. One example is that of Article 3, or the Bill of Rights, which it is also considered as a self-executing provisions of the Constitution, because Article 3 need no further legislative action in order to operate it. Right in there, in Article 3 of the 1987 Constitution could already be the source of rights which can be exercised immediately, because there are those which are called non-self-executing provisions of the Constitution, which need a legislative action in order for it to become operative, while Article 3 is considered a self-executing provisions of the Constitution, it can be implemented already even without that legislative action or no action coming from the legislature. That is a constitution of liberty. Then we also have the Constitution of Sovereignty, or that provisions pointing out the mode or procedure for amending or revising the Constitution. So this part of the Constitution is all about changing or amending the Constitution because this involves the sovereignty of the people. And that is why in changing the Constitution, it has to be submitted to the people for its ratification or for a plebiscite so that the will of the people, the voice of the people is listened to and respected. So, example of the Constitution of Sovereignty is that of Article 17 of the 1987 Philippine Constitution. So, there are two steps in amending or revising a constitution. By the way, when we say amendment, it means piecemeal change in the constitution. So, amendment is part only of the constitution is changed. Even words or sentence can be part of the amendment because it will not affect the general the constitution in general because amendment is piecemeal only, while revision means a total change or revamp of the constitution. It means that the whole constitution will be affected once a particular provision is changed. It will already make the constitution not suited for implementation unless the people generally acted upon it through plebiscite, because revision is a total change of the constitutions, meaning it will affect so many provisions of the constitution that uh, is different from that of the amendment. Now, there are two steps in amending the Constitution. As I was telling you, one is the so-called proposal. Proposal may be made by three-fourth members of Congress, wherein, well, people in Congress are our representative, and what they do will always be our voices. We elected them, so Congress has its own way of proposing changes in the Constitution. So they can. Number two, they can also be proposed, that can also be proposed by means of constitutional convention, where there are elected or the people choose who will represent them in a constitutional convention, like what Marcos did in the Batasang Pambansa, and of course people's initiative. But um, people's initiative, as discussed in one case that reached the Supreme Court, it is applicable only to amendment but not to revisions. Then the ratification or the submission of the draft constitution to the electorate. A proposal made through people's initiative requires at least 12% of the entire electorate, and that at least representing every legislative district. So let's come now to the preamble. Well, preamble is not part of the Constitution, as many books have said. However, preamble is also source of the um, common purpose as to why there is a constitution. Preamble comes from the Latin preambulus, which means to walk before. It is already defined as an introduction to the Constitution. So, since it is an introduction to the Constitution, there are some constitutions which do not have a preamble because this is only an intro. I already go directly to the point. But constitutions with preamble, though preamble is not a source of right, it embodies the purpose why there is that constitution. That's why if you read the preamble to the 1987 Philippine Constitution, you can gauge that the framers of the 1987 Philippine Constitutions have that very humanitarian consideration. Why the Constitution been passed through? Because that is already seen in the preamble of the Constitution. So the preamble of the 1987 Philippine Constitution, we, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence and democracy under the rule of law and a regime of truth, freedom, love, equality, and peace, though ordain and promulgate this Constitution. So, if you read the preamble of the 1987 Philippine Constitution, it uses the word we as an intro, which means that this is an act of the people of the state, of the elected of the state. So the word we, because that will be the will of the people of the state, of the Philippine state. So if you look at it and if you read at it, you can see that this is what the people at that particular time, this was passed. This is the aim that they want to happen when the 1987 Philippine Constitution is totally implemented, that the people of the republic will always have that love. Even love is there. So how can we disregard love when even the constitution, the introduction, which is the preamble, contains the word love? So these things are written for the people who will implement the constitution will look into in their mind and in their heart that this is what the people of the Republic of the Philippines wanted to have while we have the 1987 Philippine Constitution. Good day, everyone. Welcome to our online lecture.